I'm sorry, can answer the question. Could you go through both gates?
I think
is it impossible to go through both gates?
I think in the vast majority of suits, it probably is going to be impossible.
I didn't ask that.
There
are still
I am not going to say
cases.
that there will never be a suit where the plaintiff could satisfy the commercial activities exception, but I think that that's a gross mismatch between what Congress was targeting here, which is trafficking in all of this expropriated property, especially when the Cuban governmental entities are the main the main culprits and beneficiaries of that trafficking conduct, which Congress wanted to.
The main culprit was the Cuban government, yet Congress dropped the Cuban government as one of the potential defendants. So I don't see how there was congruity there. Two amicus briefs, the foreign sovereign immunity scholars and the foreign international law scholars, raised the Charming Betsy interpretation, canon of interpretation. We know Charming Betsy was at the founding, and we know that Congress wanted to push the boundaries of international law with Title III. But Charming Betsy cautions us to try to construe statutes not to violate international law. Here, not only is it pushing it to a private cause of action against the Cuban government and its subsidiaries, Justice Barrett has asked the petitioner's counsel whether they could also sue other countries' agencies and instrumentalities, and she said yes. What's your position on that?
Well, I'm happy to start with the third countries question, but I also want to get back to talk about the customary international law point that you were making about Charming Betsy. And with respect to third countries, footnote 5 in our brief doesn't take a position on this.
Isn't it the logic of your position? If you're saying that it abrogated the FSIA, why would that abrogation? Because it doesn't say it abrogates sovereign immunity with respect just to Cuba.
I think that several of the provisions are Cuba-specific, the ones that specific.
Several are, but not all of them.
I agree with that, Justice Sotomayor, and I think that it is clearer that there is an abrogation with respect to Cuban agencies and instrumentalities, and I think that that would be enough for the court in this case. But if you think that it's all or nothing, then I would make 2 points that would mitigate the potential risks associated with that. First, to our knowledge, there's not a single pending Title III case that brings any claims against third country agencies and instrumentalities. And
once we say it's okay, even if we reserve the question,
they make, and second,
you know that we're inviting that litigation.
And my second point is, to the extent that it looks like that's going to be any sort of problem, then the president has the suspension power, and he could suspend or partially suspend the right to bring Title III actions if he thought that that was going to create foreign policy problems. And that also was part of my answer to your question about the customary international law point in Charming Betsy, which is that the administration, the executive branch, was very concerned about exactly those types of things when this bill was being debated in 1995 and 1996. And the State Department letter that my friends on the other side quote specifically said that the suits against agencies and instrumentalities would go far beyond current exemptions in the FSIA. The executive branch was concerned about this, and I think Congress's response to that was to say, we are going to exercise our power to go beyond what the FSIA currently allows. But if you were to adopt the respondent's reading here, then that would not be the case, because it would not be able to go beyond the FSIA if they also had to comply with the FSIA. And the one change that I think Congress made after that point in the legislative development that is relevant to this is that at the executive branch's request, they granted the president the suspension power. And the suspension power is a way for the president to help manage whether he thinks that the risk to foreign policy, offending foreign sovereigns, whether we're going beyond what customary international law allows, is worth it with respect to the U.S. national interests and expediting a transition to democracy in Cuba.
Which way does the